Chris Hoffer from Bloomberg Law here. I'm at the Littler Executive Employer Conference. I'm joined at the news desk by Tanja Thompson, who is a shareholder with the firm. So Tanja, you're here to talk about union organizing today, which is a broad topic. We could probably spend an hour or two talking about that. But what I want to hear about is what's new or what's changing. Are there trends that you're seeing on either side?
I think, since the advent of the 2015 election rules with the NLRB, we saw obviously more rapid elections, and we also saw elections that were more heavily involved in terms of social media and the internet, really stealth campaigns where oftentimes employers were really caught unaware. They didn't realize organizing was going on because the traditional means of having flyers and handbills and card signing really in the workplace turned to everyone looking at their phones.
So we often look at this as an adversarial process, and I'm sure sometimes, if not often for you, it is. But are there situations in which an employer may be better off just accepting a union? I mean, workers have the right under the law.
Yeah, obviously they have the right under the law. And while we understand there's sort of an adversarial process, and we often explain that once we get to the bargaining table, really, in terms of educating employees, we're really looking at a pro-employee stance. So we believe that oftentimes for employers, having that direct working relationship with their employer is really the best way to solve problems and do that kind of thing. So we feel like having any third party, whether it's a union or your stepmother coming in, to your personal relationship, anybody that's an outside third party to the relationship sort of brings difficulties. While there are some industries still that historically have had unions, have good relationships, and perhaps it makes sense from a customer vantage point to have unions, most workplaces today say, we want the direct working relationship.
So you mentioned the NLRB election rules, which are now under review. We don't know exactly what the board will wind up doing with that, but they do have a Republican majority.
Right, finally.
Which a lot of folks think means that maybe they'll peel back some of what was done in 2015. What are you looking for
it's a great question, and the comments period's just closed, and so I think some of the key things, obviously the timing of the campaign. I don't necessarily think we need to go back to 38 or 42-day campaigns, but if we had 30, 35 days, perhaps a little more time for a hearing. Right now we're going to hearings in 8 days, and that's pretty tight. The opportunity, I think, to litigate all the issues pre-petition that we need to, supervisory status, the potential for fractured units, which I know the president has really changed a little bit on that now. And also I think the list concerns, right? The privacy concerns we have for employees in terms of producing their cell phone numbers, their home addresses. The home addresses, of course, has been there, but with the combination of the cell phone numbers and personal email addresses and things like that, I think that's become pretty cumbersome and also potentially a privacy issue for employees.
Is there a happy medium here in terms of, the people who are supporting the existing rules say, well, you shouldn't be able to slow this thing down forever to just kill the drive? Is there somewhere in the middle?
I think there is a happy medium. I think that, we were all really pretty anxious about, potentially 10-day or 14-day campaigns. We've settled in around 21 to 23, 24 days in terms of campaigns. I don't think, again, we need to go back to 38 or 42 days. I think if we can get in the high 20s or perhaps the low 30s, we could live with that. I do think it's important to have the opportunity to litigate pre-petition, some of those important issues, and if that ends up adding a little bit of time, being able to litigate and also brief those issues ahead of time so that there's not confusion as to who's going to vote or potentially supervisory taint issues or things like that. I think that is important.
And you mentioned the microunits issue. There's been a change in precedent there, making it harder for unions to organize these smaller groups. What does that mean for folks who are out there in the field?
Yeah, I think, we did struggle with some fractured units. We struggled with some micro units. This PCC structurals decision goes back to the old RAE, so we're really looking at a standard community of interest test. So I think, I think in some industries where there's some industry norms like retail, in some of those industries, we are going to see some of those original units go back where that's okay, to not carve out, again, the shoe department or the cosmetics department, the Macy's case, things like that. We didn't see as much fractured unit organizing or micro unit organizing as we thought we might. So I don't know that you're going to see a huge tidal shift. But I think, again, we are going to have a bit more of a fair shake in terms of the analysis of, shared community of interest and not sort of a gerrymandering of potential bargaining units.
And what does it mean for workers and for employers who currently have microunits that are unionized now.
Yeah, it's really not going to mean anything, right? So there's not, unless employers or employees or the unions go out and try to add on or subtract, you're really going to be left with those units, because there were, there were appropriate units for purposes of an election. There was either a stipulated election or an agreement. So unless there's a case that's still being litigated up to the circuit courts, if there have been a unit in place for a period of time, there's nothing that's going to be undoing in terms of getting rid of those units.
And is there anything else that you're looking for in terms of out of the board that will have an impact there?
Yeah, I mean, obviously we're still waiting on joint employer, right? We thought the other shoe dropped and then it didn't drop, or it got undone. So I think my understanding is there are some other joint employer cases pending, and so hopefully now that John Ring is confirmed and we have a full board in place, hopefully we'll see some movement on joint employer.
Yeah, sooner or later, I
Yes,
think we will.
yes,
Well, thank you for
absolutely.
joining us. I
Okay.
appreciate it.
Thank you.